after the R&B concert is not evidence. He or she is recruiting minors for the defendant's illegal sexual conduct. Though these other bad act witnesses, the jury was not inundated with one jarring story after the next with unconventional graphic sex acts, including sexual conduct that many, perhaps most, would consider deviant. Example, group sex, elements of BDSM or corporophilia. Hold on, y'all, my nose. I'm sniffing, hold on. My allergies, okay. The government, I'm right here. The government presented details, testimony about the defendant's sexual activities with men, group sex, and even illicit testimonies from Anna about the defendant's penchant of sexual involving corporophilia, which she can describe as demeaning, and humiliating. When considering this mass of prior bad act evidence cumulatively, it probatively valued the diminished exponentially as compared to its presidential effect. This can be little doubt that the defendant's jury was inclined to rectify past injustices by punishing the defendant, even if it harbored doubt about his guilt on the charges of offenses. The risk of prejudice and confusion was particularly acute where the trial devoted into a live rendition of the Surviving R. Kelly docuseries, replete with views of sexually explicit videos. Merriam-Webster, the definition of BDSM, sexual activity involving much practices as much as physical restraint, the granting of relinquishing of control, and the infliction of pain. Regular corporophilia marked as interest of excrement, the use of feces and filth for sexual excitement. Admission of graphic videos and audio recordings. In days upon days of testimony of other bad act witnesses was not enough. The government was further permitted to introduce private videos and graphic sex acts, some in which have BDSM elements. Government Exhibit 341 through 343 were group sex acts between Alex Dominique and the defendant, which reflected nothing but group sex, but involving two men and one woman who did not even testify. The district court barely defended the introduction of these videos for a legitimate non-propensity purpose. In a length video of the defendant spanking Anna, who was naked and crying, walked back and forth calling herself a slut and stupid while the defendant looked on. The video was offered for no other purpose than to show the defendant's sexual perversion and mistreatment of Anna. It shed no light on whether the enterprise exists or had no bearing on the charged offenses. Lastly, and most problematic, the government admitted a video of Anna spreading feces on her naked body and calling the defendant daddy, although the defendant was not depicted in the video. He was not depicted in the video? What? He was not even in the video? This video, like others, added nothing but to the equation as it relates to proving the enterprise and did nothing but breed contempt for the defendant. The defendant was entitled to a fair trial on the charges, offenses. Instead, with the district court blessings, the prosecution put him on trial for a lifetime of bad behavior, with the jury already biased against him. Argument 7. Whew. And the admission of mountain of uncharged bad acts, the defendant was denied his guarantee of a fair trial. The district court restitution award for Jane and Stephanie herpes treatment was unsupported by the government's evidence. After a hearing conducted on September 28, 2022, the district court ruled that Jane was entitled to a restitution pursuant to 18 U.S.C. 2429 for the cost of herpes treatment, namely most cost of Veltrax, for the remainder of her life at an amount of close to $300,000. The court further ruled that Stephanie was entitled to all close to $50,000 for the cost of herpes treatment, namely the cost of Veltrax and Valacilor, whatever, for the remainder of her life. Jane. We're almost there, y'all, so I'm going to finish up. Ain't no need to stop it now. The district court abused its discretion by granting Jane nearly $300,000 in restitution for a lifetime supply of Veltrax, where the government failed to establish that Jane was infected with herpes as a result of any charged conduct. Jane has been or willing to treat with the suppressive regimen of Veltrax. 3. Jane will actively treat it with Veltrax rather than Valacilor, whatever, the generic version of Veltrax, which is a fraction of the cost of Veltrax. In short, the district court abused the purpose of restitution statute to grant Jane a windfall of costs she has never incurred or will incur, seemingly to punish the defendant and compensate Jane for emotional distress. Preliminarily, the restitution sought for genital herpes treatment is not mandatory pursuant to 18 U.S.C. Since Jane contracted herpes cannot be causally linked to any Mann Act violation, the defendant was charged with a Mann Act violation stemming from a trip that the defendant and Jane took to California between April 28, 2015 and May 1st, 2015. Racketeering Act 8. And further charged with Mann Act violations related to the trip that the duo took to California in September and October 2015. Racketeering Act 9 and 2 counts through 5. Because Jane did not and could not connect her contraction to herpes with either of these trips, she is not a victim for the purpose of 18 U.S.C. Under the statute, victim is defined as an individual harmed as a result of the crime under this chapter, namely crimes prohibited by 18 U.S.C. and A and B, 18 U.S.C. Mann Act violation by its own terms. Mandatory restitution is required pursuant to 18 U.S.C. 2429 only when the harm suffered by the individual is shown to be as a result of a specific Mann Act offense. See United States versus Goodrich. Right here. The government ignores that Jane and the defendant commenced a relationship in April 2015. Jane moved into the defendant's home shortly thereafter, where they engaged in a consensual and legal relationship in the state of Illinois for 5 years. But the 2 isolated trips to California, the defendant would never have been convicted of a Mann Act violation related to Jane. The government simply cannot show that Jane affliction with herpes had any connection with those specific trips. The analysis in the same pursuant to 18 U.S.C., where there is no nexus between the offenses for which the defendant was convicted and Jane's contraction of herpes. The Mandatory Victim Restitution Act defines victim as a person directly and approximately harmed as a result of an offense for which restitution may be ordered. Thus, in determining to whom the defendant owes restitution, the statute requires that the court, 1, to identify the offense of conviction, and 2, to ascertain whether the putative victim was directly and approximately harmed by the defendant's commission of that offense. The Second Circuit explained in U.S. versus Viller, restitution may be imposed only for the losses arise from the specific conduct that in the basis of the offense of a conviction. The government has not and cannot demonstrate that Jane contracted herpes arose from a specific conduct alleged in the Charged Man Act violation or forced labor account related to Jane. Separately, the Second Circuit has held repeatedly that the MVRA requires that the offense of conviction directly and proximately harm the victim entitled to restitution. Goodrich. Courts have interpreted this language to impose cause and effect of approximate cause requirements respectfully. Again, the harm suffered by Jane, namely her contraction of herpes, must be directly and approximately caused by the specific Mann Act violation and or forced labor offense. It is not sufficient to state that the defendant and Jane were in a abusive relationship in which he transmitted herpes to her at some point. Jane and the defendant were in a relationship for over 4 years. Regardless of how abusive Jane now claims the relationship was, she was entitled to a quarterly $1 million of herpes treatment medication, whether she cannot directly or approximately link her herpes diagnosis to the specific offense in which the defendant was convicted. Assuming arguendo, the government demonstrated the sufficient causal connection between Jane herpes diagnosis and the charged offenses. The government dramatically inflated the cost of Veltrax for an uninsured individual. United States versus Maynard. The government bears the burden of proving actual loss, not losses that are hypothetical and speculative. First and foremost, the government assumes without providing any supportive evidence that Jane has and will continue to take Veltrax as a suppressive treatment rather than intermittent treatment. The government offered no affidavit, no medical records, and even a letter from Jane physical confirming that she following and will continue to follow for the remainder of her life. A daily suppressive regimen of Veltrax. Dr. Brieft testified that only people who have suffered 3 outbreaks a year typically are placed on a suppressive regimen rather than treating the infection on an as-needed basis. A simply Google search or review of the CDC guidelines show that treatments of herpes does not take one form or not everyone as directed to follow the suppressive regimen, and is mere conjecture on the point of the government that Jane has or will remain on a compressive regimen of Veltrax for the remainder of her life. Even if the government showed that Jane has following a suppressive regimen, the government has inflated the cost of the compressive treatment. Relying on www.drugs.com, the government contends that a 30-day supply of Veltrax is $421.29. However, a 30-day supply of the Valacavir is $15.31. Accordingly, even assuming that the government satisfied the burden of demonstrating that Jane will be on a suppressive regimen for V-cycle or whatever for the remainder of her life, the actual cost, total cost, is $9,829.02. Okay, and then the generic version, she divided that by 12 months and all this and that, and the years and all this and that, not in outrageous sums of $200 and some thousand. The government offered no rationale as to why Jane will need to take the brand name drug Val rather than the generic version, particularly where the government does not make the same request for Stephanie. In sum, the government cannot justify the causal connection between the offenses for which the defendant was convicted and Jane contracted the herpes. But even if it could, the government blatantly attempted to punish the defendant and enriched by Jane, forcing him to pay a $250,000 to Jane, even though there is no evidence that shows that she follows and will continue to follow a compressive regimen of Veltrax, or that she cannot treat her herpes symptoms with a non-brand version of V-cycler. Okay. Stephanie. The government seeks restitution on behalf of Stephanie for herpes treatment backdated 1999. At the outset, the record does not substantiate that the defendant transmitted herpes to Stephanie. Stephanie did not even testify that the defendant infected her with herpes. Indeed, the defendant medical record showed that he testified negative for herpes in June of 2000. McGrath began treating the defendant for herpes on the same date thereafter in that year. Thus, Stephanie claimed that she was infected with herpes by the defendant in 1999 and simply unsupported by the evidence of her own testimony. The government continually overlooked that 1 in 6 people have genital herpes. The defendant is not the source of every person on the planet with herpes. Stephanie claimed the defendant affected her with herpes and contracted by known facts. That aside, the government failed to show Stephanie's purported affliction with herpes occurred between May 1999 and October 15, 1999, during the conduct alleged in Racketeering Act 2. As discussed in Supra, the government must show that Stephanie is a person directly and proximately harmed as a result of an offense for which restitution may be ordered. Goodrich. The defendant was convicted for an act of sexual exploitation because he allegedly filmed a single-sex act with Stephanie between May 1999 and October of 1999, where she was still 17 years of age. Restitution may only be imposed for losses arising from the specific conduct alleged in Racketeering Act 2. Because Stephanie could not show that she contracted herpes from the defendant during the conduct alleged from the charge at all, she is not entitled to restitution for herpes treatment. Furthermore, the government exhibit shows that Stephanie is prescribed the generic version of Veltret, which could cost only $31 per month without insurance. Even if Stephanie was taking Vicocycle, daily for the rest of her life, the government argues the total future cost would exceed $643.02. In some, Stephanie belated claims that she contracted herpes from the defendant is supported by no evidence whatsoever, including her own sworn testimony. The defendant did not present with symptoms or began treating with herpes until 2000. Even if this court were to blindly accept Stephanie's claim 23 years after the fact, the government cannot demonstrate that the herpes was a direct and proximate cause of the conduct, specifically alleged that the Racketeering Act 2, according to Stephanie, like Jane, is not entitled to no restitution for past or future herpes treatment. The district court lacked authority to order the BOP to turn over money seized from the defendant trust fund to the clerk of the court for future restitution payments. Final judgment has entered against the defendant on June 30, 2022. As a part of the judgment, the district court entered a assessment of $900,000 to $400,000 GVTA assessment as fine of $100,000. The district court deferred as restitution finding on or around August 4, 2022, the Bureau of Prisons seized roughly $27,000 from the defendant inmate trust account without a court order, without notice, and without filing a lien on the property, without filing notice of default, and without providing the defendant receipt for the funds. In a pleading filed over a month later, the government admitted that it directed the BOP to seize the defendant's trust fund account monies and sought an order from the district court directing the BOP to turn over seized money from the clerk of court for deposit into the interest-bearing account pending a determination of the restitution. The district court granted the order. The district court lacked authority to direct the BOP to turn over $27,000 seized from the defendant's trust account because the defendant was not in default and would not provide any default notice. There was simply no authority for the government to order the BOP to seize the defendant's money. 18 U.S.C. Likewise, the district court lacked authority to direct the BOP place and seize funds with the clerk of courts for use against the future potential restitution judgment. Neither the government nor the district court cited any authority for the proposition of the government may restrain the defendant's property preemptively to use against the future restitution award that was yet to be entered. Case law on this issue is slim, but two district court cases provide some insight in the United States versus Hickman case law. The government, I'm right here. The government moved the district court to authorize payments from the defendant's trust account in order to satisfy a criminal monetary obligation imposed by the judgment against the defendant. The district court denied the request because the government failed to present evidence of default of his payment obligation. See United States versus Woodward case law. Okay. Denying the government's motion in order, authorizing the BOP to turn over the defendant's trust account funds to pay a court order fine absent any evidence that will fine is unpaid or in default. What occurred in the instant cases is even more problematic, where the government ordered the BOP to seize defendant money without first seeking leave of court. The government acted prematurely and without legal authority when it ordered the BOP to seize the defendant's money from the trust account absent and showing that the defendant defaulted on any shirk of payments obligation. The district court abused its discretion when it directed the BOP to turn over the funds to the clerk of courts for payment against the restitution award and had yet be entered. Conclusion. For the foregoing reason, defendant convictions must be reversed. Alternatively, the defendant is entitled to a new trial. Separately, the restitution award must be vacated and the defendant property seized from his inmate's account must be properly returned. Submitted, Jennifer Bongine, Ashley Cohen, the Jennifer Law Group, from the New York office to the other office, okay? And then she did the certifying date. And that was that. Thank you for tuning in to Spitting Fire. I'm your girl, R.A. Thank you for listening. Please like, share, and subscribe to the video. We're just reading the final briefing appeals, and this is the third reading. Thank you. Take care. Fire out.